Awesome. So as I mentioned, this is Putting the Wellness Court into Code. My name is Lauren Van Schilfgaard. I'm a tribal member of Cochiti Pueblo and now serving as an assistant professor at the UCLA School of Law. Before that, I directed the Tribal Legal Development Clinic at UCLA, and I believe I see Professor Sika Kwaptiwa, who also taught in the Tribal Legal Development Clinic, and both of us also were formerly affiliated with the Tribal Law and Policy Institute. I served as the Tribal Law Specialist for about 8 years with the Healing to Wellness Court program, and so this topic is very near and dear to my heart, and I probably know many, if not all of you, via that role, but it's really incredible and amazing to see where wellness courts have taken off since my departure, including all of the great work at the Tribal Law and Policy Institute. Okay, so this webinar is kind of specific in comparison to some of the other cool webinars that are part of this week, including I just want to make a highlight to the one on restorative justice by one of my former students, Grace Carson. That looks really cool, and I'm excited to tune in. This, however, is specific around the code. The tribal code, I think, for large part, is really auxiliary to the operations of the wellness court, in part because the code itself, the idea of written or positive law, laws that the equivalent of whatever the tribal legislature might be, have come together and written in a book or an online or however it may exist about what the law is. Law, of course, comes in many shapes and sizes. When you have a court case, especially an appellate court case, a tribal court might issue a written opinion, and that opinion is binding to the parties that were the litigants in that case. But it also speaks to what the law is for the tribe for future cases, so that future litigants can cite to that past case and say, well, in this case, they held a certain way. Our situation is really similar, and so we're going to borrow from that case law to inform what the law should be for this case. Many tribes also actively point to and engage with their customs and traditions. In many tribal codes that I've looked at, they actually explicitly identify custom and tradition as relevant and binding tribal law that is on the same footing as the tribal code as well as case law. There also might be a body, especially a growing body of administrative law, decisions that are coming out of various agencies, as well as court rules or other things that might be happening on different levels. All of these things inform the body of tribal law. Tribal law, of course, is distinct from federal law, including federal Indian law, or the body of federal law that applies to tribes. It's distinct from state law, the state constitution, state case law, state statutes, as well as international law. All of these things might be happening simultaneously from the tribe's perspective. International law, federal law, state law, other tribal law may all be persuasive and informative for what the tribe is doing, but ultimately, tribal law is the binding authority for what's happening within the tribe. So why does this matter to the wellness court? I think for a long time it didn't, in part because the wellness court is a disruptor in a lot of ways. The wellness court is I think for some tribes, an explicit rejection of the Western adversarial injection of what law should be. The whole premise of case law, of positive law, even of court, administrative law, are real Western notions that purport to be the only legitimate form of law. Tribal dissent to that, I think, is recognizing custom and tradition, but of course, pre-contact, it's not that tribes were without law On the contrary, tribes were operating really sophisticated body of laws that were oppressed and suppressed for centuries, but now are really either being revitalized, rediscovered, built for the first time. In all these scenarios, are expressing their own legitimacy in a lot of ways. And the Wellness Court operates in kind of a unique position to that. I think in certainly yesterday and in future webinars, there's a long recognition about the origin of the Wellness Court as serving in these dual worlds, as many things within tribes do. It is coming from the drug court movement. So in a lot of ways, it's not very indigenous and it's not very old. Coming out of the 1990s, a recognition that quite a few parties within the court system have a substance abuse disorder or some other interaction with substance abuse that is deeply informing their presence before the court, including their engagement with criminality. And the general traditional criminal responses are just not terribly effective in the face of substance abuse treatment. So the drug court comes into being as a more explicit attempt to address what is the large elephant in the room, substance abuse. But I think for tribes, there was an immediate recognition that the drug court as a model was deeply familiar, and that this thing that we were trying to articulate, why the Anglo-adversarial system was both foreign but also incomplete picture of justice, the drug court started to round out a little bit. I think the more and more we've engaged with this work, the more we've realized that even the drug court model is also just a partial articulation of a more fuller justice that tribes are starting to articulate for themselves and on behalf of the rest of the world. Nevertheless, it's been super useful, both in an abstract, what is tribal law sense, but also in an immediate practical need that tribal communities are similarly facing lots of substance abuse, both for ways that are also familiar and comparable to non-tribal communities, but also in ways that are deeply tribal responses to not just familial or even intergenerational trauma, but massive community, multi-century trauma that are requiring responses that need to be crafted by tribal communities and simply aren't being crafted elsewhere. Okay, so what does this have to do with the code? Tribes are operating their own tribal legal systems, including tribal courts. The Wellness Court has come out as a friendly borrowing of the drug court movement. It is neat, it's tidy, but it's also a rejection of the Anglo-adversarial model. And so to the extent that it's not adversarial, it is grassroots, it's organic, it is more reflective of a traditional system that's more restorative. Maybe it shouldn't be in the code at all. We're just going to do our own things in the traditional way, in the same way that other custom and tradition does not appear in the tribal code. The Wellness Court shouldn't either. I think that's a perfectly reasonable way to go. And in fact, looking at tribal codes and the ways in which they interact with wellness courts, that often is the area where tribes land, that the Wellness Court shouldn't appear in the code. But I'll make one intervention, or I'm going to make several interventions, but my primary one is that to the extent that the Wellness Court exists, and it exists as a version of the tribal court, I think there is something to be said for recognizing its existence and putting it in whatever variation of tribal law is the most relevant to the tribal community. As a researcher looking at lots of tribes, most of which are not my own, I have found the tribal code to be an increasingly useful tool to identify where the tribe stands, what they're doing, and what their values are. And so even if the tribal code is merely a vehicle to provide external expressions, hey world, this is what we're doing, there's a lot of utility in that. There's a lot of power in being able to say, our tribe is doing this. We have a wellness court. We prioritize the wellness court. We're seeking funding for the wellness court. How do you know that? You can look at our tribal code. But as we'll go through, there might be some other considerations for why you might want to put the wellness court into your code. And if you do that, what specifically should you be codifying? All of this comes with a giant caveat. There is no two tribal codes that are alike, even tribal codes that borrow heavily from the same source. More and more as tribes are starting to legislate more, their codes are going in different directions. Different tribes use their codes for different purposes. Some tribes haven't updated their codes in a long time, and so the code just isn't used that much, at least as the most relevant source for what's going on. And so it's just going to really matter how a tribe is interacting with their code. Lots of codes are structured differently, and so that structure is going to inform what would be relevant to include. But I also would point to the extent that it's like, oh, I wish our code was more useful in this way, or we don't really use our code and I wish we did because it'd be nice to have like that accountability there. Putting, like looking forward, this might be an opportunity to do that. No code is static. All law is dynamic, and all law is only as relevant and useful as we engage with it. And so even just the process of attempting to get something into the code can be an arduous and frustrating, but also extremely useful and unifying process. And so I don't want to make light that these are easy things to do. And that's like more true in some tribes than others. But all of it, I think, are worth discussions, internally with our advisory committee, with our team, with the law and order committee, with the tribal council, with the community. I think that there are going to be lots of different opinions, and merely engaging in the conversation might reveal new issues, but also opportunities that potentially could be useful. And if it doesn't work, it doesn't work. The conversations are always going to be beneficial. Okay, so with that, I think we will dive in. Like I said, I welcome questions and comments as we go. I'll attempt to address those as we go through, but I'm also going to reserve time at the end. So if you have like a bigger, broader question, feel free to throw it in and maybe we will get to that at the end. Okay. Code considerations. So the structure of the wellness court. Lots of wellness courts are structured similarly, but that doesn't mean that they are by any means uniform. This can include both like what comprises a wellness court, what even is a wellness court has lots of variations. The publication that this is based off, and I'll have a screenshot in a minute, assumes a wellness court as envisioned by the Department of Justice, specifically their coordinated tribal assistance solicitation, or the CSTAS funding, in purpose areas 3, 7, 8, and 9, I think. And so this is a separate docket overseen by a judge that includes a prosecutor, maybe a defense advocate or counselor, a treatment provider, a case manager, maybe a law enforcement provider, and then maybe some other ancillary team members, usually in a criminal docket, but potential opportunities for either a juvenile delinquency docket and or a civil docket, usually for parents with a dependency or child welfare matter. But the criminal model tends to be like the driving force. And the idea is that a person has been arrested for a criminal offense. It is determined that that offense was either motivated by or happened contemporaneous to a substance use disorder that the participant has been diagnosed as having. They are then given the opportunity to divert into the wellness court, such that there is always this looming criminal prosecution hanging over their head, either as they've already been prosecuted or the prosecution has been deferred. So they have a choice, but it is a coercive choice to go into the wellness court and complete the wellness court in lieu of the consequences of this criminal offense. And so in this way, a healing to wellness court is only kind of restorative justice. In some ways, it's pretty punitive. It's not a fully voluntary program, except to the extent that like the criminal process is always there. So you're motivated, you're incentivized to participate in the wellness court. And it's structured this way under the guise that substance abuse treatment, at least in theory, is an option in the community that this person always had the opportunity to avail themselves. However, they didn't, and now they're facing this criminal prosecution. And so we're going to leverage this criminal prosecution to further motivate them into treatment, something that they didn't otherwise take advantage of. But now we can pressure them into and hopefully take advantage of this opportunity for not just the betterment of this person or their family, but the community at large. That's a broad strokes the idea. Now, how the wellness court is structured within the tribal legal system may differ. For lots of tribes, the tribal court, the wellness court, is a component of the tribal court. So they conceive of like, okay, we have our general jurisdiction tribal court, we have the appellate court, and we have this wellness court happening to the side. It's a separate docket. Maybe they get their own case numbers. Maybe there's a separate courtroom. More likely, the wellness court uses the courtroom on Tuesdays. Maybe there's a separate judge, maybe it's the same judge, but when the judge is in the chambers of the wellness court, that is different than when they are in the chambers of the general jurisdiction court or the appellate court. For other tribes, it's not so much a separate docket or a judiciary. It's conceived more of like a program or a diversion program or a condition of probation. So it doesn't necessarily have its own case number. Rather, it's something that's happening that may happen to take place in the court, but isn't really a court in the same way that the general jurisdiction court is. That's all relevant because if you're putting this into your code, the way that you think of how the wellness court operates is going to inform where in the code you might be. Most wellness courts, if you were to look up where is this in the code, it's in the judicial section. But for other ones, it might be in like the criminal code, or it might be in like a programmatic section. That all matters. And even there is a strong signal to the community, to the external world, to internally, and to amongst other tribal agencies. What is the wellness court and how should I think about it? Structure of the tribe. I mentioned the role of the code. How is this used? For some tribes, code's not super useful. For other tribes, the code is everything. If it's not in the code, it doesn't exist. Conversely, the code is the vehicle into operations. If the courts frequently are only legitimate to the extent that the tribal council or the legislative body has acknowledged them into existence. And so a wellness court wouldn't be able to operate unless the code writes them into existence. So I think for many tribes, this is where it becomes most relevant, that in order for us to exist as a court, we need to be acknowledged in the code. We can't be doing our own thing on the side. That sort of like organic, experimental, just simply isn't authorized by the code. Unless a court is recognized in the code, doesn't exist. So we need to be codified. Separation of powers. This is a unique issue in Indian country, in part because the Indian Reorganization Act did not inject a requirement for separation of powers. And so some tribes, this is a big deal. Some tribes, it's not. Sort of just depends. But to the extent there is a concern about who is operating the wellness court and whether or not we need to build in safeguards to ensure that either the tribal council or some other variation of an executive and legislative branch are interfering with the operations of the wellness court, which are conceived of as a judicial entity. We might need to build those in. Or do we perceive the wellness court as a non-judicial entity? In which case we want to plop it over here. And so that the tribal court's operating over here, wellness court is over here, and you don't need to worry about it. Structure of other tribal agencies. Do other tribal agencies appear in the code? Are their duties enumerated such that if we want to add on wellness court, we need to specify that in the tribal code? Or do they have a broad recognition of duties and we don't need to worry about that? Do we need to think about, especially because a wellness court is a collaboration of multiple different parties that have otherwise been siloed in the Anglo-adversarial model, do we need to restructure the whole way that tribal agencies appear in the code in order to make the wellness court feasible? Hopefully not, because that's a big job. But on the other hand, from a principled abstract view, this could be kind of cool. We're completely reworking how we think about how these agencies operate and the maybe unsaid underlying principles that are informed by these Western models of how agencies should be operating, what their obligations are to the tribal government and to the community, what sort of transparency principles they have. I'm thinking for example, law enforcement, which has a public trust component, but particularly since 2020, that public trust has been really compromised. What ways are the tribal police sort of involved in that conversation? And how does their appearance in the code inform their ability or their desire to participate in the wellness court? Sort of big questions, but the wellness court is just one thing to think about. Okay, I got a question. Can I speak to whether a unified therapeutic court code is advisable versus adopting different versions to fit a specific area, juvenile, adult, family, veterans? Well, this is kind of a big question, and I think there's a couple of different things that are going on there. So pros and cons, which goes to our benefits and disadvantages. I think the benefit of having a unified therapeutic court code is that you can keep it simple, which ultimately I think is sort of the driving number one consideration. Less is more, in part because modifying the code should be difficult. If your code is constantly changing, it makes it less likely that it's a useful code because it's going to be hard to find the right version. There's also probably less consensus about what those changes were. And so it should be simple. So in a unified therapeutic court that says, there is a therapeutic court, it may include adult criminal, juvenile delinquency, family civil, but those are up to the discretion of the judge or the Wellness Court Advisory Committee or whoever it might be. If I want to have some sort of unifying principles that apply to all of my courts, including my adult criminal and my family, I might say that there has to be a judge, there has to be a separate docket. Maybe they have to have their separate case files. There needs to be a holistic, principled approach and an access to treatment and all of these things. The advantages for getting specific means that you can cement those specific programs, especially if I want to use the code as an accountability mechanism that I think the wellness court is a good idea. But maybe my successor doesn't agree with me, or I know that there's a lot of resistance in other agencies. I might want to get the wellness court into the code because it's difficult to get it out and use that as you might not like wellness court, but the code says you have to do it. So tough, you might as well get on board with this. And so I might want to get specific that there shall be a therapeutic court docket, and that docket shall include both an adult criminal and a juvenile delinquency docket. These are now requirements that the tribe is accountable to ensuring that those exist on behalf of the community. The community can therefore use the code to hold the tribe accountable. The code says you have to do this. You aren't doing this, and so now I have a cause of action to hold the tribe accountable to ensure that this happens. Some tribes might condition that it's like, we shall provide this as if feasible, i.e., if there's money to be able to do this. Do you want to give the tribe an out for funding? That may just be a practical necessity that you have to, versus like, no. The tribe needs to prioritize this. There's always going to be funding issues. We're always going to have to make a priority list, but too many times the wellness court drops to the bottom of the priority list. We want to elevate it to the top. These are considerations for the code. I'll be going into some more specific area considerations for the juvenile, adult, family, and veteran stuff. And so, Diane, keep this question and like bring it up again if you feel like you have some more specifics about which way we should go. But I think the answer is like, it depends. But if you pressed me, I would fall on the unified version. Okay, some more benefits. As I mentioned, stability. Putting it in the code says there's a wellness court, and so this isn't like someone's baby. This is now the tribe's obligation, which is really nice. By putting the wellness court into the code, it identifies what the wellness court is and specifically what authority they have. This is great, especially because if your code requires, say, that only like the code is the only source where an entity has the authority to say, put someone in jail. Then if the wellness court is going to use jail as a sanction, we need to specify that the wellness court has that authority to do so. It also has the benefit of maybe putting barriers around what authority the wellness court can do. The wellness court might be super creative, but maybe not this wellness court, but we could imagine maybe a future judge that like doesn't really know what's going on, hasn't quite gotten the training yet, goes rogue and starts going way outside the boundaries of where we envisioned the wellness court's principles to be. We can put stop gaps at least on what authority the wellness court can operate. Codifies restorative justice. I can only imagine that Grace is going to be really getting into this later this week, but I think that as the wellness court is not just a shuffling of different agencies in the way that they operate. It's not just a diversion program to sort of postpone or even hopefully avoid incarceration. It's a real reorientation of what the tribal court is, what we're trying to do, what the community can expect from the tribal court, how we might want to perceive the way we engage with the community going forward. Putting this into the code is a real like foot in the sand. We're redefining what justice is. And this is important, not just for the way that we engage day-to-day business, not just what you can expect from us, but as we build more, this is just a starting point. This may just be step one in what a future restorative justice panoply might look like. That to me is like super exciting. And so I think the code can be like a building block, but you know, practice first, principled second. Some disadvantages. Putting something in the code feels sort of backwards to the extent that the wellness court is organic and dynamic, and we're feeling it out as we go, and we're making changes. Putting something in the code kind of puts a halt to that. We've just cemented something that maybe wasn't supposed to be cemented. And so there can be really disadvantages to doing that. You might be halting, slowing, minimizing the creativity that you once had to experiment in the wellness court, which is where I come back to, is it good to get specific or general? I think general. If for no other reason, then you don't want to paint yourself into a corner unnecessarily. To the extent you are, it can be really a hard process to change the code. And so at best, it's just slow. There are advantages to slow, but there are also disadvantages. Third, and this always seems counterintuitive to me, but the fact is the code, at least the ways in which we have engaged with it for the last 250 years, it's adversarial. It comes from this English system that is documenting a judicial structure that is envisioned to be adversarial. And so even the structure of the code, even when we're trying to have restorative justice principles, we're using like a format that is intended for an adversarial system. So a lot of the ways in which the wellness court appears in the code is really highlighting the adversarial moments of the wellness court. Now, I think that's okay, right? Because the whole point is that you're in this criminal system that is definitely adversarial, and we're trying to, point you over here. But what's happening over here isn't in the code. That's in the wellness court. All the code is doing is saying, in these adversarial moments, here are the opportunities that you can get into the wellness court. So I think it's okay, but I do want to highlight what ends up happening, and the way that it appears on the page is like, wow, the wellness court isn't actually not that different from an adversarial system, as opposed to these are just the adversarial moments in which the wellness court is engaging with the other adversarial system. Pat has a big long question, but she says to save it to the end, so I'll save it to the end. Okay, so these are big, fat, principled systems. Now we're going to get into the weeds a little bit. Here is the publication I was talking about. This is one of the many brilliant free publications available to you for free from the Tribal Law and Policy Institute. You can download this and interact with it. The one thing that this has that we won't be going over in this webinar is lots and lots of examples from actual tribal codes. What I did was I basically did a rudimentary search through tribal codes that are publicly available, codes that appear on tribal websites, and pulled out where I could find wellness courts mentioned and used them to inform this presentation and this publication about how you might think about codifying. Lots of different ways in which tribes have codified, and say like one example of like, what should we name our wellness court? Lots of different examples for how tribes have approached that and many other questions. So it's really intended to highlight the variety, the variation amongst tribes, to sort of give you permission that like you can experiment here, but also give you some like questions to ask. It's really hard to think like, oh, we should codify the wellness court. Like, what should we what should we even be thinking about? This hopefully gives you some ideas about like, here's some things you can think about, but to the extent you feel compelled to just copy and paste a single tribe's codes, that might be a good example, but hopefully this will better inform you about picking out the pieces that you like and leaving the ones that you don't. Okay, so now we're going to get into entry and discharge. This is where most of the bread and butter is for codes. I mentioned that, to the extent that the code is the adversarial moments of the wellness court, this is most prominently true for how you get into the wellness court and how you leave the wellness court. Most codes tend to be silent for what's happening once you're in the wellness court. That is found in the policies and procedures document or some other document for which the wellness court is operating and determining its own structure. The code seems to be most concerned with how you get in and how you get out. And I think that is not a coincidence, right? I think as far as the code is concerned, we have some concerns for due process, Is it fair for how you're getting in and out? And is there a procedure for how that takes place? Equal protection. Do the same, participants that are similarly situated have access to the wellness court? Is there an explicit reason for why certain people have access and certain others don't? And then what happens when you leave the wellness court? If you successfully graduate versus if you were terminated or kicked out, what's the procedure for what takes place then? And how does that participant re-enter the Anglo-adversarial system that is operating under a very different model that may or may not be restorative? Okay, so establishing the court. Many tribal codes begin and end here. They merely say the wellness court is a thing. It exists. Consider this part of the tribe. They might name the wellness court. Even the term wellness court is a variation of the non-native drug court. Many tribes adopt healing to wellness court or wellness court, but many other tribes have a name that is based on a native language within the tribe. And I think this is the coolest thing ever, and sort of one of those that I think in not so many years from now will point to tribes have really started to bring in the native language into the judiciary. There are now names for all sorts of different agencies and dockets within the court that are based on a native language. And this began with the wellness court, but it didn't end there. But even if it ends with the wellness court, I think it's totally appropriate to use a native language to name and use the native language to inform these more restorative and traditional values for why the wellness court exists. This is by far my favorite part. In the publication, there are a couple of examples. They're all cool. And also the English translation for the name is also really cool. They're not just like wellness or road to recovery. There are things like the place where the healing begins, or lots of different variations. They're really cool. If you don't look at anything else, check out the native languages section. Authority, I mentioned the authority, the wellness course that exists. This exists as a docket of the tribal court. The wellness court has the authority to say, issue incentives and sanctions, order drug testing, order a variety of different orders for this participant, but only for the confines of 1 year, or only up to the sentence that this person might have faced had they stayed within the adversarial criminal justice system. This is where you can be expansive and narrow for what your wellness court can and cannot do. Lots of reasons to provide and limit that authority depending on the accountability of the wellness court, the notice that you want to give participants for what they're entering into, but also discretion for the court to respond to the variety of different needs that may come before it. Jurisdiction. Who can get into the wellness court? Is this just criminal adversarial criminal offenses? Is it also juvenile delinquency? Is that one wellness court, or do they operate separately? Who can come in? Purpose. Not all codes, in fact, not even half of codes necessarily have a purpose. I think it's really interesting to put why does the wellness court exist into the code. I think that one should tread lightly here, in part because it's the code. And so to the extent that somebody could potentially use the purpose section to say the experience that they had in wellness court was not reflective of the purpose as articulated in the code. And so they wanted to maybe litigate about that. I think, the tribe retains sovereign immunities, so I wouldn't be overly cautious about this, but I would certainly want to involve the tribal attorney in this type of discussion. But the purpose can be a really beautiful section to inform the wellness court itself, other tribal agencies, the rest of the tribal government, the community, future litigants, but also the external world about what the tribal wellness court is doing and why it's doing it. I think that the benefits are massive. And so to the extent there are any disadvantages, I don't know how real those disadvantages are. I'm just like speculating, but I think check out the purpose sections. They're really broad, and I think there's opportunity for like where your mission and vision statements could come in. They're pretty neat. These some codes are very simple. There hereby is a wellness court, and that's it. That's enough. I think if anything, I would advise all wellness courts to have this within their code, sort of regardless of what considerations or how your code operates or what your wellness court is doing. I think there's a lot of power to say there's a wellness court. And so maybe it has funding, maybe it doesn't, but either way, we have the authority of the code to exist. I wanted to just give a couple examples of what the jurisdiction is, especially as wellness courts are perceived as a diversionary docket. The wellness court is a trial court of special jurisdiction with jurisdiction to hear all cases that are referred to it. That's a tidy way to say that the wellness court has limited jurisdiction. One can't appear in the wellness court as like original. You can't file a case in wellness court. The only way to get into wellness court is to be referred. And so that's a tidy way of like, we're not going to get into the specifics of who is eligible in the code. That's again for a separate document, such as the policies and procedures. But we are going to say that the wellness court exists, and it exists only to the extent that participants are referred to it and accepted by the wellness court. Here, a separate code provision gets a little bit more specific to say that referrals have to meet the eligibility criteria that's in the policies and procedures manual, and they have to be accepted. So these are just examples of things that I've seen in different codes.
Hi, Lauren, you have someone who has their hand up in the chat.
Oh, cool.
I'm going to allow them to talk to ask their question.
Go back.
Roxanne?
Yes, good morning.
Good morning. Oh, I can't hear anything now.
I didn't hear you because it was breaking up.
I can hear you now. Go ahead.
Oh, okay, did I have a question? Did I raise my hand?
Oh, I thought so, yeah.
Oh, no, I didn't think I did. I'm sorry.
Oh, no problem.
I'm so sorry.
No, you're good. This was a good test for if you have a question or not. Well, no problem. We'll keep it moving, but as you can see, you can raise your hand, which is a useful tool. Okay, some more examples for establishing the wellness court. In the top one, you see an example for articulating the wellness court as a diversion program. I highlighted just a couple of words that popped out to me that were useful here. The healing to wellness court shall. In code drafting class, shall and may are two really important terms that are useful to distinguish between. May is permissive, right? The code is recognizing that the wellness court can do something, but the discretion lies with the wellness court whether or not it has to. Shall is an order. You have to. The wellness court has to be a deferred sentencing program established to avert those offenders with substance abuse problems. So here's narrowing. The only offenders that are allowed in the wellness court are those with substance abuse problems. So they have narrowed the pool of people that can be in here, away from the regular court system and toward a more holistic approach, which involves a treatment-oriented perspective. That is very broad language, right? A more holistic approach. You can be anything you want as long as it's more holistic than the regular court system, but it has to involve a treatment-oriented perspective. And so this gives a lot of discretion to the wellness court for how to realize that, that vision, but it is a vision that is in the code, and so they're at least held accountable to that. Authority. The wellness court shall, again, mandatory, have the authority to issue all orders. Now, this is important. This really, really depends on how the tribal court is structured, but to the extent a court can only do what the code says it can, then this is going to be a critical provision in order to give the wellness court sufficient breadth to have the flexibility to do creative incentives and sanctions, as well as case management plans that are actually responsive to the need of participants. Issue all orders necessary. Now, it could have just said issue all orders necessary and given the wellness court all the breadth in the world to issue whatever orders that it wanted to. Instead, this provision narrows that to say, ensure the safety, well-being, and rehabilitation of individuals who come within or consent to its jurisdiction. Okay, still pretty broad, but it's at least narrowed that it has to be connected to the safety, well-being, and rehabilitation of that participant before them. They shall have that power to implement all the duties, responsibilities, and remedies. So their authority extends not just to issuing orders, but also to implementing any other necessary action in order to be responsive to the participant. Again, whether or not I would want to put this into the code depends on like what authority I need to give the wellness court in the code, but I think this is a perfectly fine example of recognizing not only that the wellness court exists, but they're allowed to do stuff. All right, marching right along. Entry. Like the authority of the wellness court, we may or may not need to give permission in the code to who can authorize entry into the wellness court. This is critical because this is one of those like legal moments where the wellness court is really different than the Anglo adversarial system. There is typically a very regimented process for how, say, a criminal prosecution takes place. Law enforcement has the authority to make an arrest. The prosecutor has the sole prosecutorial discretion on whether or not to bring charges. The judge is not authorized to initiate a criminal offense. Similarly, other community members or even tribal council are not authorized to bring a criminal offense. The wellness court operates a little bit differently. We may entertain and likely bring in most of our participants via the prosecutor who has brought charges but recognizes maybe that this is going to be a good case for the wellness court and refers over to the wellness court. But we may also want to authorize entry by other persons. I realize I skipped ahead of myself on one slide. For this slide, how we are structuring that entry is also relevant. Does the prosecutor have the authority to refer cases to the wellness court before prosecution, or can they only do that after there has been a conviction? Such as, do we recognize the wellness court as a deferred sentencing? So there has to be a conviction, but we will step in before there is sentencing. Is it instead a sentencing option that you've been convicted of this crime and your sentence is either jail or to go to wellness court? Versus as a deferred sentencing, your sentence is jail, but we will stay that jail sentence if you elect to go to wellness court. And if you successfully complete wellness court, then you don't have to go to jail. We'll just throw out your sentence. Other tribal courts will use the leverage of even a conviction, of a potential conviction, to incentivize. We are going to bring charges and we're going to have a trial. But before we do that, you have the opportunity to go to wellness court. If you successfully complete wellness court, then we won't prosecute. And that means you won't have any criminal record, which is way better than just not going to jail. and then post plea and pre-conviction operates sort of in between there, where we are, that we're in the trial, but you've made a plea agreement, a plea bargain that includes wellness court. So that's all very criminal oriented, hence this criminal model focus. There should be a similar recognition, especially for operating a civil dependency or juvenile delinquency, how those referrals might work into the wellness court. And then I also put in here a transfer from foreign jurisdiction. By this, I mean, we are starting to see really cool things happening, both within the joint jurisdiction model, but also just in a more informal or a less collaborative tribal state collaborative agreement, such as what I'm thinking is there was a DUI and it happened in the county side off tribal lands, but the participant is a tribal member and lives on tribal lands. The county recognizes that this person is affiliated with the tribe, calls up the tribe and says, we have this person holding for a DUI. Would you consider taking them into the wellness court? And we'll do the whole adversarial on our side as say a deferred sentencing, but recognize their referral to the wellness court as a transfer from our jurisdiction. Does the tribe have the capacity in the code to negotiate with that? I think there are lots of cool models in which this is happening, recognizing that the boundaries as they exist today are largely artificial, are the needs of our community, Does the tribe have the capacity to respond to that, regardless of how the case originated? Okay, back to the referral points. As I mentioned, the prosecutor tends to be a primary one, but as opposed to the Anglo-adversarial system, does the code recognize the potential for multiple other referral points? What if the defense counselor wants to initiate a referral? What about a law enforcement officer or a supervising officer? Do we allow self-referrals? Can a participant elect to come into the wellness court themselves? Does the code even need to authorize that? If it does, do we need to put it in the code? Similarly, what's not on here, can the judge recommend a referral to the wellness court? Eligibility. Many tribal codes will touch on eligibility to some extent. I think that this starts to get in the vein of how much is this relevant to the code versus relevant for the policies and procedures manual, especially because I think this goes partially to Patsy Kakwepiwa's point. The drafters of the code are ultimately very different than the drafters of the policies and procedures manual. The manual, in theory, is being written and negotiated by the wellness court team, the people that are actively engaged in the day-to-day work of the wellness court. We tried this, we saw it worked, we tried that didn't work. We're going to tweak the manual a little bit to be more responsive to what our practice is telling us, versus the code, which is likely being negotiated by either a law and order committee, a subset of the tribal council, or the tribal council itself, that is maybe democratically voted, maybe not. Maybe there is general council input, and so it's the entire community. Either way, it's a more political process, and it's drafters that are likely less engaged in the day-to-day work of the wellness court. And so to what extent do we want to use the code to broaden or narrow our eligibility? It depends, but that's exactly what we're doing. Eligibility is to broaden or narrow who can get into the wellness court. Lots of reasons for why we want to broaden or narrow, resources being one, fairness, relevance. Are they appropriate for the wellness court? That might be a perfectly reasonable criteria to put in. Authority of the wellness court. These are the only people for whom the wellness court has recognized power to serve. So I think where the code is potentially its most useful is for this top right-hand column, the process for determining eligibility. I think it's totally relevant and reasonable to look to the code and say, how does one get into the wellness court? Who determines that? And for the code to say, this is intended for those with a substance abuse treatment, or maybe even more broad, this is intended for those for whom the tribal court has deemed appropriate for a restorative justice approach. More specific eligibility criteria can be determined by the wellness court team and the policies procedures manual at their discretion. I think that's a perfectly reasonable way to say we are delegating authority to the wellness court team to make their own eligibility criteria. Maybe the code puts confines that eligibility criteria needs to be fair and it needs to be reasonable. Maybe it needs to be published so that people know what the eligibility criteria is. But from there, it's like it's out. We're not going to limit the team. We're going to give them the authority to determine what that eligibility criteria is themselves. Some specific due process considerations. This is where I saw the most explicit examples of the code being super adversarial, merely because it was identifying conflicts with the adversarial system and the wellness court model. Noting especially if the wellness court operates as a pre-conviction or a plea bargain type process, then there hasn't been a conviction yet. And so for those wellness courts, the idea is that if you successfully complete, there's no conviction. But if you don't, if you get terminated, then after you get terminated, we're going to reignite the adversarial process and pursue prosecution. Well, then maybe it's been 6, 8, 10, 13 months since the offense was originally committed. You may not have a speedy trial. It may have been a minute, but you elected to do that. And so we're putting specifically into the code, by opting into the wellness court, you're waiving your right to a speedy trial. Not all codes do this. And I think that you could get at this right, say in the agreement document that the participant signs, or in the policies and procedures document. But I'll note that for, as to the extent that this butts up against the Indian Civil Rights Act, I've seen this in some code. Similarly, stipulations to preserve evidence for deferred prosecutions, especially if there is a concern about witness availability. Maybe we're going to take down some affidavits and sort of agree that this is a true accounting of that witness's testimony, even though we may not have the ability to cross-examine that witness at a later potential trial. Does the wellness court provide access to a defense advocate or counsel? If not, is that different than what the participant would be entitled to in the adversarial criminal court? I think it's okay that they're different, especially because there's different rights at stake. But if they are different and the code bothers to articulate what the right to counsel is in the criminal adversarial system, we might want to bother to articulate what that right is in the wellness court, especially if it's different. Conditions of entry, noting that if you come into the wellness court, you're giving up some potential rights that you should know of. And you should have, there's lots of notice stuff in the policies and procedures manual. And so this hopefully is just duplicating that in the code. And for that reason, you may or may not want to put it in the code, but I've seen it in there, noting that you may be required to abstain from substances, including alcohol. So including substances that might otherwise be legal, maybe such as cannabis, that there might be mandatory drug testing, that there might be other restraints on your liberty, such as a nightly curfew or a curfew on weekends, that you're going to be expected to disclose some of your medical records to team members, including team members that are not medical professionals, such as the judge. You should be aware of that. All right, and then finally, discharge. I think this is a good place for the code to articulate what happens when you leave the wellness court, especially because there are legal consequences to this departure, both on the criminal and the civil side. If you successfully graduate, is it automatic what happens, or is it at the discretion of the judge? Is it, if we have, just like our wellness court is deferred sentencing, and so after you leave the wellness court, for everybody, your sentence is deferred? Or do we want to leave it more open, especially because we have more open entry points? A neutral discharge. I don't see a whole lot of codes speaking on this, but I might encourage you to think about it. What happens, say, like somebody has to leave the wellness court, but it's not because they were kicked out and they didn't successfully graduate. So examples of this, say, are they move, they leave the jurisdiction, and so they're leaving the area. Well, we need to have them exit the wellness court and like all of the restraints on their liberty that we had on them, but we don't necessarily want to punish them. So do we have a process for recognizing a neutral discharge? And then termination. What happens if you're kicked out? Is there clear notice about what the consequences are? If it is at the discretion of the judge, do we have some sense of what might happen? And should that be in the code? Okay. Finally, there are just a couple of things in operations that I'm going to brush through really kind of very overview level, in part because these tend to be a smaller part of the code, and I think are just fruits for like thought, things that you may want to consider when you're looking at what should be in the code as a reflection of our wellness court. Team roles and responsibilities. I think a big opportunity for the code is team composition. Early on, some of the biggest resistance for getting the wellness court off the ground is the willingness of other agencies to participate. So one way to do that is to say you have to. Why do you have to? Because the code says you have to. I'm sorry that you don't think wellness court is a great idea, or that you don't think that that this is part of your like job description. Now it is. Do we need to articulate specifically what their job is? I note the responsibilities of each team member, particularly the judge. Some judges get it. Some judges lead this and build the wellness court. Other judges have a very specific idea about what their role is and may see the wellness court as outside of that, or inappropriate or unethical. I think the code can be a useful place to assuage those concerns and help reinforce that we are doing something different and that we have different principles and different ethical values that should guide you in this work. And the code can be a place to help with that guidance. Finally, the wellness court coordinator is usually a role that does not otherwise exist in another agency. A lot of teams have trouble justifying that this should be a separate standalone role, especially for funding. Putting them in the code and making this like an accountability metric can be a useful way to say like, oh, we have to hire a wellness court coordinator. Code says we do, sorry. Court procedures. This is all over the place. Tribes have lots of different ideas about what should be in the code, specifically regarding the procedures. As I mentioned, for the most part, these belong in the policies and procedures manual. I don't think that the code needs to get too involved in the day-to-day operations of the wellness court. Nevertheless, there might be some instances where the code does want to. Records. If the wellness court is a court of record, do we need to provide parity between the wellness court and other tribal dockets to ensure that we're building a sufficient case file? Who has access to that case file, especially because we have different team members? Unlike other tribal dockets, these persons have access to the wellness court case files versus these persons don't. I'll also just note like case management, treatment plan, supervision, drug testing. A lot of codes will merely note that these things exist and they're going to take place. Some codes get really specific, and I can only imagine why they needed to get that specific and what led there. I think, right, there's like pros and cons, but keep in mind, the more specific you get, the more difficult it is to adapt. The hearing. This is where codes tend to get specific, in part because the code might be very specific for other dockets. And so there's a need to recognize that the wellness court, even though restorative, even though doing a thing by a different set of rules, is nevertheless operating a hearing for which we recognize there are some due process protections that the tribe is accountable for ensuring. And so we want to note, say, that the wellness court, even though they have hearings, and those hearings are weekly or some measure of frequency, do not necessarily operate by the same rules of evidence. They're not a court of record. We may or may not be recording them. Specifically, what you say in a wellness court hearing may not be used against you for other charges. Or do we want to cabin that? Maybe admissions to substance use, even use subsequent to your original offense, are not going to be used against you. But what if a participant admits to a different crime? What if it's a violent crime? Do we care what kind of crime it is? Is there a threshold that we want to identify where what you said in wellness court or in any other setting can be used against you? And should we note that? Confidentiality and privileging protections. Do we have concerns about who else is in the hearing and what they hear and what they are allowed to say or not say, especially if other participants are in the hearing for various other participants? Usually that's not a concern because hearings are open, but something we may want to consider if we want to close the wellness court hearing. Here you can put that it's mandatory that other people come. Sorry, you're part of the wellness court team. Code says you have to come. And I'll note staffing. There's always a huge concern about the appropriateness of staffing, especially for the judge. And so I think it's super appropriate to put in your code here that concerns about having a discussion about a participant, even if the participant isn't in the room, is okay. Finally, incentives and sanctions. I think there are some legitimate due process concerns here, especially if a wellness court is using incarceration as a potential sanction. There is usually a very extensive process or procedure that's required in order to sentence someone to jail. That's good because jail is a very intense restraint on your liberty. Do we have a recognized process for the issuing of a sanction, including even if it's only for incarceration? Is it fair? Do we have a process to ensure that a rogue judge or a rogue wellness court is not going to abuse participants under the guise of being restorative? I think that there are lots of different ways that you can build that assurance. But I want to just bring it up that if you were to hand the keys of the wellness court over to strangers today, do you feel confident that they would do good work, even though you don't know who they are, what their values are? Do we have a process for ensuring that the good work is going to continue after us? Some codes will specify a list of appropriate incentives and sanctions that the wellness court is authorized to use and prohibit going off of that list. Advantages, you give lots of notice to the community and future participants about what's at stake, which is great. Disadvantage, you remove any and all flexibility. And so I think some of the better ones end up in the middle where you give a such as list to give the court some guidance, but also some flexibility. All right, well, we are just about out of time. And so with that, I'm going to say thank you and give the evaluation code, but also open it up to any questions. And I definitely want to highlight Pat's statement on here, which I think is a great place for us to have in line, is that putting things in a statute will privilege tribal council decision makings over the wellness court team. It's important to be very carefully weigh what goes into the policies and procedures manual and what minimal provisions might go into the statute or the code. For example, you would not want a list of sanctions and incentives codified in the team, as we just noted, and particularly case manager and treatment provider need to work with each participant to understand what incentives and sanctions would move their behavior. This is going to vary. Question: what are the recommended minimal elements to be included in the statute? Well, that's a tough question. For me, I think that there are some primary due process considerations. And so I want to ensure that, to the extent that tribes have been compelled to adopt this Anglo-adversarial model, and we can debate whether or not that's a good or bad thing, I think that it means that tribes have similarly adopted the potential to be a coercive and abusive government. They may not be, that may not be their tendency, but it's a concern because that's the concern of the model. And so I think that we can use the code to put a barrier against that as much as possible while still providing all of the incredible opportunities and flexibilities that make the wellness court a much more exciting and responsive and ultimately efficient model for the community. And so I think I think that the best codes are simple. I think they're straightforward, and I think they are silent in the name of giving flexibility to the wellness court. So simply saying that you exist, I think, is great. I think providing some clarity and expectations for how you get in and out are really useful. And from there, I think the rest is really negotiable. Are there any other questions? All right, well, I see that we are a minute over, and so I just would like to extend my gratitude for sticking with a virtual webinar, which is not always the most engaging format, and so I really appreciate your attendance. I hope that the rest of the week's presentations are great, which I'm sure they're going to be, and I would just like to tip my hat to all of you for engaging in this really incredible work and giving me so much great material to work with. Please feel free to reach out to me if you have any other questions, and certainly to the Tribal Law and Policy Institute. I'd also like to just give another plug for the evaluation. They're so incredibly important, and I know for a fact that TLPI reads them and incorporates their input directly. And so for your own sake, but certainly for ours, we appreciate your insight. Thank you very much.